One iwi did subsequently withdraw their statements about the vegetation removal, and there was further conversations with the iwi representative. It became clear that their concerns related to 42 Pateroa Road, the site that already had the consent granted. So that meant that there was a discussion, but it ended up with the understanding being that there wasn't concern about 40 Pateroa Road, it was about 42, which had already got its consent application.
Yeah, but I'm just in the context of the recommendation for better practice for the future. What I'm trying to get the message across is, which I thought would be obvious, is silence is not consent. That an objection is an objection and should be noted as such in the context of the information that was provided, and we've already heard been said that not the full information relating to the application the removal of vegetation was provided, so inadequate supply of information, which again, from my argument, would mean that you, the duty commissioner, failed to address the matter of consultation as required under the Act as being reasonable, because the information wasn't fully provided as should have been required by the applicant. I accept that council offered the service of a facilitation service and the applicant chose otherwise to their own path, but clearly what I'm seeing is a letter that lacked responses. How can that, and now I go back to my question again, how can that be deemed to be adequate to servicing consultation as required under the Act? And that's a significant matter here, because is it the same person, the duty commissioner, that first determined whether it be notified or non-notified and then determined the consent to decline or uphold?
Yes, the same commissioner was both decisions.
So this is a point I make, is that you're relying on limited information to determine whether it should be notified or non-notified, and that same person who determined it should be on that limited information, in my view, is also the same person issuing or declining the consent. I think that's a practice we need to be wary of. Yeah. Because you're asking the same person the same question twice, and of course you're going to get the same answer. But the reality is that what is the benchmark? And I think that's what I want to make, Madam Chair, is very pertinent here, is about the baseline for determining adequate consultation as required under the Act. I think we need to be clear about that in this Auckland Council regime. And that also brings me to the issue of contentiousness in terms of applications. So I'm a member of the Hearings Committee, and I receive, or as part of an agenda, matters that are contentious. So why wouldn't have deemed this contentious now it's so contentious?
So at the time of processing the consent, we had received correspondence from a couple of neighbours and comments from the local board. It's not uncommon for us to receive letters from neighbours about proposals, and it didn't meet the threshold, and that would have been a decision that I would have been part of. It didn't meet that threshold for it to be considered to be contentious at that time.
Sorry, and the threshold is?
Yeah, so the threshold, there's not a scientific formula for it. It would be my judgment. My judgment together with my stuff.
So, Madam Chair, I guess to help with the recommendation and the review process, we should be surely taking that burden away from individuals and creating a clear benchmark and threshold for people to understand, including the community, on what's a contentious issue or what's not. I certainly want to say that as a member of the Hearings Committee, it would be very helpful for me to understand that as well, because of the perceptions that could be realised of the Hearings Committee role on this, which had no role, because at the end of the day it was already gone off to the duty commissioner, and we get reported on the result, not participate in the implementation of the result. So I just wanted to offer those things, Madam Chair, based on the questions I've asked. I think there's a lot of scope to move on this process, a lot of things that could be locked down better, and I think that people need to fully follow through on those processes to safeguard us all. It does, although, leave me a concern about where we are today on this current application, and I would hope that if the council thinks could have done better,
I don't know.
then why doesn't it seek a judicial review on the Duty Commissioner's decision? Because let's remember this, that the Duty Commissioner is an independent commissioner who's not council. That's why they're called independent commissioners. So the reality is you're not actually doing a judicial review on yourself, you're doing a judicial review on the decision made by the Duty Commissioner who's independent from Auckland Council.
Okay.
Kia ora.
I might just get, and this question has been asked, I'm just going to get James to re-clarify. James.
Yes, Member Taiperi, the independent commissioner is obviously independent, but they're acting under delegated powers.
So it is the council then?
It is the council. It's,
Not
a,
really,
council, it's a council decision.
Funny that.
So let's be really clear about that. It's a really, really important, this is a decision of Auckland Council. So a review, which is the point I was making earlier, a judicial review would be Auckland Council moving to judicially review Auckland Council. We can go through it all again, but I think it could not be clearer. 3 times now we've had that.
Madam Chair, can I ask this question
Yep.
then? Has council never ever appealed decisions of a Duty Commissioner before?
James?
I know the answer, James.
Yes, we have.
Thank you.
Yes, but we're out of appeal time for this particular matter.
No, the point I'm making is what I'm hearing is how ludicrous it might be to review itself, but because of the Duty Commissioner. What I'm saying is council's done it before by seeking appeals on decisions made, which in my view is reviewing the decision and seeking an alternative decision.
And I would just add to what I've said before, the only decision that could actually be reviewed in this instance is the notification decision.
I was talking in general principle, James, on that one.
But I would certainly,
Yeah, okay.
I would advise against it.
Okay. And just for clarity, notification isn't a presumption of a consent being declined. Notification simply is notification, and it may well have the same result. I'm advocating most strongly that we look at our threshold issues around notification and communication. I've got Councillor Lee, Councillor Brewer, Councillor Cooper.
Thank you.
That didn't mean I didn't want to speak.
Thank you, David.
Oh, sorry, Member Ngamani. Just hang on, Councillor Lee. Member Ngamani.
Yeah, kia ora. Just before I ask a couple of questions, and my colleagues kind of covered a lot of what I might have wanted, so I'm not going to repeat myself. But just some clarification around the resolution. A lot of our conversation has been around how we can review this to improve our internal processes. Is the reason we're not explicitly saying that in the resolution because you don't want to be seen to be judicially reviewing or opening up? I mean, for a sole and specific purpose of pretty much moving it on to the current review of the Resource Management Act. What I'm saying is all the conversations appear to be how can we improve what we're doing going forward. Is there a reason why that isn't being explicitly said?
And I think we can make that more explicit by, and just give me a moment, and while we go around, I can see exactly what we can change in there. We'll do it, because I'm really clear that this is for us
As well,
and that was going to, in the part of the report back to the Auckland Development Committee in April, that was us taking our processes and saying, where are these key areas where we can improve. If we need to make it more explicit in here, I'm happy to do so, so we'll work on that, Leanne.
Thanks.
I am really clear, though, I'm not moving a recommendation that is initiating a judicial review. I couldn't be clearer about that.
Just touching on the process of the consultation, in particular with iwi, what expectations do you place on an applicant in terms of when they need to consult? If you essentially provide the choice for either an applicant or council to undertake the engagement or communication on a consent, do you provide any parameters around or expectations of the applicant, i.e. can they start their consultation after they've lodged the application, the day they're going to lodge it, or is there an expectation that they're actually engaging on this stuff prior to moving through the process, or is there just no?
I think you've hit on it. As this process, and as I said at the beginning, the unitary plan's been in now for just over a year, and these provisions came in with that, and it has been a work in progress to how we improve that progress. And certainly now that the staff are more familiar with how the rules work, and also the planning community, the external consultants who prepare applications are more familiar with it, we are moving that consultation and discussion to the beginning of the process rather than after applications are prepared, wherever we can. So we are strongly encouraging at pre-application meetings, and whenever people raise issues with us, if we identify that there may be a requirement for a cultural impact assessment, we are urging people to start that conversation as early as we can, or we will start to facilitate the sharing of information as early as we can. But yes, definitely it's an evolving process, and we're wanting to get better at it, but I think it's something that we look at during this.
Appreciate that, but in respect to this issue, that process wasn't in place.
With respect to this issue, my understanding is that the applicant chose to go directly. They can get the list of the relevant iwi, and they went directly by sending emails, the letter, and a copy of some of the information about the application to them.
At the time of lodging the application, post lodging the application?
Look, from memory, it was just pre, but I can get that confirmed for you.
Just this question about one of the iwi groupings who came back and made it really clear that they didn't support the removal of the tupuna taonga, that I understand that they referred to. How do you, and I think Council's response was that related to 42, noting that the rimu was part of that application, but how did you get to it not referring to 40?
My understanding is that there was further discussion and that it was confirmed that the concerns were about 42 and not 40, but I'm happy to look back through that and get back to you, but that's as I understand it and as articulated in the report. So there was some concern, but then when the discussions were undertaken and it was drilled down, it related to 42, and 42 had the consent already.
Well, I appreciate that. My understanding is that all correspondence that was forwarded related to 40, Paturoa, not 42. Although a subject heading may have been in a report somewhere that related to 42. That's my understanding. So it would be good to clarify all those potential errors that did occur through that process.
Okay, thank you, Member Ngamane. Councillor Lee.
Yes, David, in your PowerPoint presentation and in your verbal summary of the application, I was intrigued that you didn't mention the Waitaki Ranges Heritage Area Act once, and Section 13 of that Act has quite a lot to say about resource consents. Would I be right in suspecting there is something of a blind spot within the council about resource consent processing in regard to the Waitaki Ranges Heritage Act, Area Act?
No.
There's not a blind spot?
No.
Okay, just that you never mentioned it at all. The tree itself could well be argued to be a heritage feature under the Act. In the past, we've had quite a lot of discussions since I've been in this organisation over the fate of houses in Ponsonby in your previous role. And I've always respected your professionalism. The houses that worried me and my constituents in Waitemataru Golf.
Councillor Lee, can we stay in the Waitakere Ranges? Okay. It would be useful.
Okay, I was just saying that I was, in the past, I've been concerned about 100-year-old houses, but I want to talk about the age of this tree because it seems to have been something of an issue. Some people believe it's 500 years old, and you have advice to say that it's only, inverted commas, 200 years old. I heard member Ngamani talk about tupuna taonga, and what that really means is if it's 200 years old, not only was it around about the time of Captain Cook, but a whole lot of illustrious Maori chiefs that we know are in the historical record were around at that time. So that gives it an enormous amount of historical inherited significance. There's nothing, if you say only 200 years old, there's nothing else much around that's 200 year old in this country. So I again do raise questions about how the council considers the implications of these heritage features within the Act that Parliament brought down, namely the Waitakere Ranges Heritage Area Act, and how Parliament felt councils should process resource consents giving particular regard to that Act. So I still have real concerns about there, and I do think in the comments made by Member Taipari that I think if anything's judicially reviewable, how the council interacts with that Act, particularly in this case, would raise significant questions. In terms of the independent commissioner or commissioners, and I'm not sure whether there was one or two, you suggested one, I hear there may have been two, but and how it, we won't go into the matter of independence, but there were two decisions made. One was to clear the land and cut down the trees in question, but also another decision was the effects of doing that, cutting down at least 200, let's seek a consensus.
Madam Chair, point of clarification, are we questions or debating now? I'm not quite sure.
We're still...
I'm asking a question.
We're still in questions, sorry, we're just also trying to do this stuff.
This is a very important question, Member Councillor Cooper.
Disputing that, just asking where we're at.
Oh, good.
What was, in the decision not to notify, and given the advice by that the effects were no more than minor, which I don't think any reasonable person would agree with, but in terms of non-notifying, I think a lot of the anger in the community is all about that. And I've heard from Mr. Kimpton and yourself how many resource consents are received and processed by this council. Could I ask what percentage of those resource consents are notified?
I haven't got the figures in front of me, but I could certainly...
I've got a letter here that suggests it's just over 1%, but anyway, it probably hasn't, that's a wee bit out of date, it's a couple of years old. But anyway, given that the local board objected, given that at least one iwi group objected, given that the neighbours objected, and given that the Waitakere Ranges Heritage Act is a legal fact, would that, do you not agree that that would amount to what the RMA under section 95A called special circumstances? If not, what would be special circumstances?
I think we just need to modify the question and maybe just have a general explanation of special circumstances. Slightly leading question.
Just in general terms, the Streamlining Act, which came in I think 2013, has moved the presumption away from notification to more of a non-notification position. So special circumstances has been interpreted by courts to be something truly unusual. in
An
relation
act of Parliament, for instance, will that...
Well, hang on, I'm coming to that, if I could just finish. In relation to the Waitaku Ranges Heritage Area Act, Section 9, if you have it in front of you there, does say if a conflict arises between this Act and the Resource Management Act, the Resource Management Act prevails.
But the Resource Management Act talks about special circumstances.
Councillor, can we just let
Okay.
the lawyer answer the question?
Yes, so there's that contained in the Act itself. Coming back to the particular applications, the Act and its provisions were very clearly right up front in the reports referred to. So they were in the front of the reporting planners' minds and certainly before the decision makers' mind.